A warm welcome to our second webinar, which is the second in our hopefully long series of sessions titled Industry Conversations. My name is Refuleli Sufi. I am the chairperson of the SAICE Johannesburg branch. As the COVID-19 pandemic leaves carnage in the wake of its devastation throughout the world, we hold in our thoughts and prayers those who are infected and those who have lost their lives to the pandemic. We would also like to hold in prayer and in thought George Floyd and Collins Khoza. We had our first session on the 14th of May 2020, where we had more than 400 registrations and around 204 participants who attended on the day. They joined directly on our webinar on Zoom platform and also through Facebook. So welcome to everyone who is joining us through the two platforms. At that first session, our CEO and President discussed the report which were prepared by the Engineering and Construction COVID-19 Response Task Team. One of the recurring questions from that session was how to handle contractual claims which were resulting as a result of the pandemic. Now, late March, the South African government announced a national-wide lockdown. This announcement was abrupt and it really disrupted all industries and the economy at large, but it was a necessary measure in order for our government to save the lives of South Africans. The changes that have been brought about by the pandemic were so rapid that employers, engineers, and contractors did not have sufficient time to be able to wrap up projects and construction sites as per the provisions that are made in the contracts that they are administering. In today's session, we will be focusing on the implications, considerations, and evaluations of the GCC in light of the COVID-19 pandemic. To introduce our speaker and to moderate our Q&A session, we have the privilege of having Stephen Kaplan, who is our COO. And our expert on the matter was also part of the panelists at our inaugural webinar. So some of you who attended our first session will hopefully recognize Theunis. My job is very simple today. I'm just going to tell you about the program, how we're going to be running this webinar. After I do the welcome note, I will hand over to our COO, who will do the introduction of our presenter. After that, we will have Theunis, who will give a well-prepared presentation on the implications and evaluations of claims that have resulted from the GCC. We're really hoping that you're going to take a lot out of this discussion in order for you to be able to manage the contractual matters that you might be facing. And then we're going to have a 30-minute session where we're going to be dealing with Q&A session, which will be led by our COO. And then towards the end of it, I will come back and give a conclusion. And during that conclusion, we will have a discussion as to what our next webinar is going to be. A couple of housekeeping rules. If you look on your screen, you will have an icon which has two bubbles there, the Q&A icon. Please feel free to post your questions. The more questions, the better, because we want this webinar to be as interactive and as possible, so that your answers can be, your questions can be answered by our experts. And then we will be recording the webinar and you will be receiving a link so that if you've missed anything or if you've forgotten anything that was discussed, you can go back to that link and remind yourself. We are going to be sending out a short survey where we would ask you for your input as to how can we improve our webinars and what sort of topics would you like us to present? What kind of specialists would you like to see in our next webinars? Without further ado, I would like to hand over to our COO, Stephen.
Good evening, everybody. Yeah, it's definitely my honor to introduce Theunis van Zyl to you all. TNS has 27 years of multidiscipline industry experience in both project and contract management, ranging from multi-story buildings and structures to infrastructure development. TNS has vast experience with procurement and delivery of engineering and construction contracts for both public and private sector clients. He also has experience in dispute resolution, dispute prevention, contract drafting, adjudication, mediation, and arbitration of contracts in many countries around the world. He is an accredited training provider in GCC and JBCC and is currently engaged by the City of Cape Town on training programs. TNS also published a book in 2009 called Managing Construction Contracts with GCC. On behalf of SAICE, TNS has volunteered countless hours vetting the new GCC subcontract and also fulfilling the role of portfolio manager as SAICE's go-to expert, responding to countless GCC queries that we receive, many of which contribute to building our GCC frequently answered questions database for our website. Also, he co-authored the recent SAICE notice, which was titled Dealing with the Effects of COVID-19 in the Ambit of the SAICE Suite of Contracts. TNS is the principal of the company Van Zyl Associates, which is based in Brackenfell, Cape Town, specializing in construction law, project management, and training. TNS is a professional construction project manager with SAC PCMP. He's an accredited mediator with the London School of Mediation. He's a professional technologist with EXA. He has a certificate in arbitration with the Association of Arbitrators. He's been conferred with a Bachelor of Technology degree in Civil Engineering and Construction Management by CPUT, and he also has many other qualifications which are probably too numerous to mention here. TNS has an appointment to the Executive Committee of the Master Builders Association, Western Cape, for the 2019-2020 year. He is a corporate member of SAICE, and he's a voluntary member of the SAICE PMCD, which is the Project Management and Construction Division in the Contractual Affairs Committee. TNS is actively providing adjudicator, mediator, and arbitrator services on each of the following organizations: our SAICE President's List, the MBSA Adjudicator and Arbitrator Panel, the Association of Arbitrators South Africa, the Arbitration Foundation of South Africa, and finally, the Society of Construction Law in the United Kingdom. TNS undoubtedly has an impressive track record of successful adjudications, mediations, and arbitrations under his belt. So in closing, as the author of the SAICE notice I mentioned earlier, TNS is undoubtedly more than qualified to speak to all of you this evening on the subject of this webinar, which is impact considerations and evaluation of GCC in the light of COVID-19. Thank you very much. Can I hand you over to TNS?
Thank you, Chair. Thank you, Stephen. Good evening. Construction claims, a practical approach and the evaluation of contractual claims submitted in terms of GCC 2015 as a result of COVID-19. So let's just deal with some foundation principles in dealing with claims in terms of GCC 2015 first, because as we understand in engineering, foundation principles are always important. So if we look at the GCC 2015 rationale, and I take it from the office desk of the GCC 2015 and the previous editions, and you can also refer to the management guide. First principle is that the risk of unexpected events will be carried by the employer and not by the contractor. The second one is then, which follows that, is the contractor need not to allow for such events in his rates and prices when he prices the tender. The third one is the contractor has a right to claim additional time and or compensation if he's delayed or disrupted by events that cannot be attributed to the contractor's own fault. So there's a compensation available in the GCC 2015 contract. And then if an event is uninsurable, the employer is responsible for the payment of damages, and we're talking about financial damages suffered by the contractor. And then the fifth principle that I just want to cover, and that is was stated in Berger versus South African Railways. It was established in 1903 already, that contracts do not have to be fair. So in Cool Ideas versus Hubbard and another in 2014, that was confirmed again by the court that the claim on the basis of fairness could not overrule the express provisions of the contract, whether such provisions are interpreted as to be fair or not. So it's quite important to keep that into consideration, especially when it deals with the assessment of contractor claims. Let us just quickly look at contractual notices, because when it comes to claims, usually there is a notice that must precede such a claim. So contractual notices, why must that be submitted? Contractual notices are required to provide both parties an opportunity to mitigate and to employers to consider each position. So notices are important, and that's why there are time requirements or time limitations in terms of the contract why notices must be submitted. And the purpose of a notice is that it puts both parties in a position to maintain and verify records for the purpose of determining the financial effect of a claim or variation order. So a notice puts the employer in a position, especially, that if there is an event or circumstance that will delay or cause additional cost, then the employer has an opportunity with his employer agent to say, listen, we need to look at how we're going to record these events so that we can interrogate it later when there's a cost assessment that must be done. And then contractual notice periods are not optional. It is prescriptive, it must be complied with. And I refer to the case of Group 5 building with the Minister of Public Works and Land Affairs in 1997, where the judge said the following: where a contract requires the contractor to give notice and full particulars within a certain period, if it intends to hold the employer liable for any loss or damage caused by dislocation or delay in the execution of the works, and the contractor has not complied with such requirements, the contractor will not be able to enforce such a claim. So a notice provision in the contract is important, and that is why the GCC 2015 has got notice provisions that must be complied with. So let's just look at the principle of time barring of notices and claims. Time barring clauses are permissible, subject to consideration of reasonableness and fairness, and that was determined in the Barkhuizen versus Napier case in 2007. And that follows from that, the timelines provided in the GCC 2015 to submit a notice and a claim are considered to be reasonable and fair, and especially on the provision that a contractor has got 28 calendar days to provide such a notice, which is obviously reasonable and fair. Then there's a provision in GCC 2015 clause 10.1.4, which provides a full time bar clause. And let I just quote this clause to you. If in respect of any claim to which this clause refers, the contractor fails to comply with the 28-day notice period in clause 10.1.1, as read with clause 10.1.2, or does not deliver his final claim within 28 days of the event of the end of the event or circumstances, the due completion date shall not be extended, contractor shall not be entitled to additional payment, and the employer shall be discharged of all liability in connection with the claim. So there's two parts of this clause that's important. Firstly, when it comes to time barring, there's an obligation and a penalty on the contractor. What's the obligation of the contractor? The contractor must submit his notice within 28 days of the events or circumstance. What is the penalty or the sanction on the contractor? Obviously, if the contractor does not comply with that notice provision, the due completion date shall not be extended, the contractor shall not be entitled to additional payment, and importantly, the employer shall be discharged of all liability in connection with the claim. And that's the penalty for the contractor not complying with the notice or the claims provision. So let's just look at what the requirement of a competent notice. Firstly, the requirement for a notice and a claim must comply with Clause 10.1 of GCC 2015. And GCC 2015's Clause 10.1 is the Notice and Claims Procedure Clause. That is the clause that dictates how the contractor must submit his notice and what's the requirement of those notices and claim submitters. And secondly, a notice is only required if a contractor cannot, by reason of the nature and circumstance of the claim, submit its detailed written claim within 28 days after the circumstance, event, act, or omission giving rise to such a claim has arisen or occurred. And look out for that. It says has arisen, past tense, or occurred, past tense. Clause 10.1.1.2. But a notice must be submitted within 28 days after the circumstance, event, act, or omission giving rise to such a claim has arisen or occurred. And then what is a claimable circumstance or event in terms of GCC 2015? It's where any clause that refers to Clause 10.1 or additional payment or compensation. So a contractor can only submit a claim in terms of 10.1 if there was another clause that referred to Clause 10.1 as a claimable event for additional payment or compensation. Then just to continue, a notice must be in writing, and in writing is defined in Clause 1.1.134 of the GCC 2015. You can go and look at that. And then a notice must comply with as much of the requirements of Clause 10.1.1.1, which are the requirements of a written claim as the contractor reasonably can provide at the time. There may be events or circumstances where the contractor can only give notice on what he knows at that stage. So, for example, COVID-19, there was a lockdown which was enacted. The contractor gave notice of that lockdown, but as we all know, that lockdown was also extended, and the contractor could only give notice at the time it was enacted in terms of what was available in terms of information at the time. Then the requirements of a competent claim. Now the contractor must comply with the provisions of Clause 10.1.1.1 to 10.1.1.1.4 of GCC 2015 on the following. The contractor must provide the particulars of the circumstance, event, act, or omission that must be explained. So the contractor must explain what are the circumstances or event that is applicable in terms of the claim, and that basically requires the contractor to give a sequence of events and a layout of what occurred. Then the contractor must provide the provisions of the contract relied upon in terms of the claim. So the contractor must quote the clauses that he relies upon in submitting his claim. Then the length of extension of time and the basis of calculation, we're going to get to that a bit later, and the amount of money claimed and the basis of calculation. So those are the requirements for a competent claim in terms of the GCC 2015. Then in terms of the length of extension of time and the basis of calculation, I just want to spend some time on that. The contractor has the burden of proof to claim an extension of time. Clause 5.12.1 deals with extension of time for practical completion. So the contractor must prove that the delay will actually extend achieving practical completion of the works beyond the due completion date. So the burden of proof in terms of Clause 5.12.1, as read with 10.1 of GCC 2015, is that the contractor must dispose of that burden of proof by a cause and effect analysis on the approved program. And that is important because in terms of the program, there may be float available in that program. It depends on what is the approved program current at the time when the delay has occurred. So that burden of proof must be done on the approved program, and the approval of the program is obviously also dealt with in GCC 2050. Then just on claims for the extension of time, if we can just spend some time on key principles. An extension of time clause exists in the contract for the benefit of the employer. It's not for the benefit of the contract, it's for the benefit of the employer. So the employer can reserve its right to recover liquidated damages or penalties in the event that the contractor failed to meet the due completion date due to acts of prevention. So it is for the contractor to pursue its entitlement to claim an extension of time if an excusable event arises. An excusable event is a claimable event in terms of the GCC 2015. It is not the employer or the employer's agent's duty to grant an extension of time in the event that the contractor failed to pursue the appropriate remedies, and the remedies in the contract is the appropriate clauses that provide for an extension of time. Just the difference between a delay and a disruption. A delay event relates to delays to the overall project completion time, and a disruption does not necessarily cause a delay in achieving the due completion date. A disruption may occur on a subcritical activity that may have some float available, and the disruption does not necessarily cause a delay to overall project completion. Then let us just quickly deal with the concept of float. It's always a contentious topic. The ownership of float should be expressly dealt with in the contract. It should be stated in the contract in writing, because the GCC 2015 does not deal with float. So in the absence of an express term, in other words, if there was nothing stated in the contract in writing, then the project owns the float. And if the project owns the float, it means it is available to the first person who can use it. It can either be the employer or the contractor. What's also important, there's two types of float. There's activity float or free float, and that's the time available to an individual activity without it affecting a succeeding activity, and it then may not affect the due completion date at all. Or there's project float, which is terminal float. It's a free time shown after the completion date up to the contract completion date, and that is the float. If that float is eroded, then the overall project completion will be affected by that. Then, if we're done with the principles, let's look at the contractual basis for a claim arising from the COVID-19 pandemic. Now, what is the circumstance or event that a contractor can rely upon in terms of GCC 2015? Now, the claimable circumstance or event in terms of clause 10.1 can only arise under, and as we said before, and I quote, any clause that refers to clause 10.1 for additional payment or compensation. So that's where a circumstance or event will arise in terms of GCC 2015. So in terms of COVID-19, the claimable circumstance or event is based on the provisions of clause 8.3.1, 8.3.1.7, 8.3.2 of GCC 2015. Now, clause 8.3.2 refers to clause 10.1, if you go and read that. So that provides the basis for a claim, and clause 8.3.1 deals with the definition of accepted risk, and clause 8.3.17 deals with epidemic, famine, or plague. So those are the circumstances or event that can give rise to a claim due to COVID-19. Now, if we look at clause 8.3.1 specifically, in terms of the definition, the accepted risk are risk of damage or physical loss, and I just emphasize, or any other loss caused by or arising directly or indirectly as a result or consequence of. So let's just look at any other loss. Any other loss in terms of this definition in 831 includes the financial loss a contractor may have suffered due to an accepted risk. And such loss is caused by, or, and I quote, arising directly or indirectly as a result or consequence, unquote, of COVID-19. So what is the sequence of events that happened here? It's not the lockdown that happened first. It's first COVID-19 that happened in the world and then in South Africa. And that is the accepted risk. That was the root cause of the delay that was caused. Then from COVID-19, the lockdown was declared, and then financial losses and delays were suffered by contractors. So it's important to note COVID-19 was the root cause, and COVID-19 is covered under the accepted risk provisions of GCC 2015. So let's look at contractors' entitlement to pursue a claim under clause 8.3.2. 8.3.2 says, if in carrying out the works, I emphasize in carrying out the works, any of the accepted risks causes the contractor to suffer delay to practical completion and or brings about proven additional costs, comma, the contractor shall be entitled to make a claim in accordance with clause 10.1. So that is where the entitlement starts for a contractor to submit a claim due to COVID-19. Therefore, the contractor must have been busy carrying out the works, and I'm going to get back to the importance of that. The contractor may claim an extension of time plus time-related general items. The contractor may claim proven additional costs to recover his financial loss. So that's where the entitlement starts. Now let's look at different scenarios in when is the contractor's notice due, because there must first be a notice before there can be a claim. Scenario number 1, the contractor experienced a loss due to COVID-19 before the lockdown period commenced. So the contractor must give notice within 28 days from the date he became aware that he will suffer any loss caused by or arising directly or indirectly as a result or consequence of COVID-19. And let's look at an example. The contractor's key staff may have been expected on the site and carrying out the works is delayed. Or secondly, special materials or plant that's only available from another country. And we already saw that on some projects before lockdown started in South Africa. Some projects were already affected by the lockdown that was happening in China and other countries. So it may have happened in terms of scenario 1 that there was a delay even before the lockdown period started in South Africa. Scenario number 2, when is the contractor's notice due? The lockdown was announced by the President on the 23rd of March 2020 and the lockdown was gazetted on 25 March 2020. So the contractor should have notified its intention to claim no later than 24 April, and that is 25 March 2020, which is the gazetted date, plus 28 days, which is calendar days, plus 2 special non-working days that also appeared in the notice period. So the extension of the lockdown announced on the 9th of April would not require a contractor to submit a further notice because the original notice would have covered the event already. Let's look at scenario number 3 on when is the contractor's notice due. So the lockdown came to an end on 30 April 2020, but the contractor was not allowed to recommence with the works under the level 4 risk-adjusted strategy. In this case, the contractor notified its intention to claim no later than 24 April 2020. And then the contractor, because he could not carry on with the works from after 30 April, the contractor must provide a monthly update in terms of clause 10.113 of GCC 2015 before the end of May 2020. So an updated notice is important in terms of this scenario. Scenario number 4, the lockdown came to an end on 30 April 2020 and the contractor was allowed to recommence with the works under the level 4 risk-adjusted strategy. So in this case, the contractor must now submit his written claim within 28 days from 30 April 2020, excluding the 1 May 2020 special non-working day because that's not counted in the timeline, provided that there are no further impact on the contractor as a result of the COVID-19 pandemic. And the reason why I'm stating that is that the contractor's delays does not necessarily stop when the lockdown period was over and he could commence with the works on the 4th of May 2020. Then scenario number 5. Lockdown came to an end on 30 April 2020 and the contractor was allowed to recommence with the works under level 4 risk-adjusted strategy. If the contractor suffers further delay to practical completion and or proven additional costs due to requirements and constraints imposed by the COVID-19 occupational health and safety measures in workplaces, that document was gazetted on the 29th of April 2020, then the contractor's claim should become an ongoing claim. So that is only if the contractor is affected by these health and safety measures. Then the contractor must provide a monthly update in terms of clause 10.113 of GCC 2015 before the end of May, end of June, etc. That is only if the contractor is affected by these measures in terms of productivity on site, workforce, supplies that may have been delayed in the schedule of supply materials, etc. So we've covered those scenarios on the notices. Then when is the contractor's claim due in terms of scenario number 1 to number 5? The contractor must submit his claim within 28 days after the end of the events or circumstances. Now, the end of the events or circumstances will be when the contractor suffers no further loss caused by or arising directly or indirectly as a result of consequence of COVID-19. So it may be that the contractor did commence with the works, for example, on the 4th of May. He's not affected by any production on site. He's got his full staff complement that may work, but it may be that the supply of materials or specialist equipment, especially from other countries, are not available, or due to lockdown, suppliers are running behind schedule, and the contractor may be affected by the delay in the supply. So that's why I say the end of the lockdown period is not necessarily the end of the events or circumstances, and it may continue during the different risk-adjusted levels or even thereafter. And we will only have to see in good time how all of this is going to play out. Then let's continue to the assessment of a contractor's extension of time claim. Now, contractual compliance is quite important. A contractor's claim must comply with the requirements listed in clause 10.1111 to 10.1114 of GCC 2015. And then in terms of 10.131, the employer's agent must investigate all facts and circumstances related to the claim. And then the employer's agent must be provided with records in the form approved by the employer's agent, and that shall be provided by the contractor in terms of construction equipment, labor, materials, including subcontractors relevant to this claim. And then in terms of clause 10.132, the employer's agent may record his own facts and circumstances in relation to this claim. And then the employer's agent and the contractor are required in terms of clause 10.133 to set out in writing and signed by both their respective agreement or disagreement with the records and the information, because that can become an agreed record of an agreed fact, and that may become conclusive evidence in the event that the claim is not resolved and it becomes a dispute. And it's just important to note in terms of clause 10.136, which provides a warning to the employer, the employer's agent, and the contractor to record any fact or circumstance in terms of clause 10.1.3 as a party in dispute proceedings being prejudiced by such non-recordal may then rely on this clause and raise an exception in the dispute proceedings. It's quite important that the employer's agent and the contractor agree what they agree to or disagree to in terms of records or facts. Then if we look at assessment of an extension of time claim, and we look at scenario number 1. Scenario number 1, the contractor is not commenced with the execution of the works when the lockdown commenced, and it's only the contract that commenced. And it's important that we look at the difference between the two. The commencement of works instruction was not yet issued, and that instruction will obviously only follow when a contract has commenced and the contractor has provided all these contractual deliverables. Now in this case, if the commencement of works has not commenced yet, but the contract and the employer has signed the contract, then the contractor must be awarded an extension of time, as the due completion date is calculated from the commencement date of the contract and not the commencement of works date in terms of clause 1.1.1.14 of GCC 2015. Scenario number 2. Contractor was already in delay with the progress of the works when the lockdown commenced, but he has not exceeded the due completion date yet when the lockdown commenced. Now, concurrent delay exists when two or more delay events occur at the same time and all have an impact in achieving completion by the due date. Now, the difficulty usually arises when one of the delays is an employer risk delay and the other a contractor delay. In terms of scenario 2, if we look at the Malmaison approach, and that approach was also supported in the recent Walter Lilly case, the Malmaison approach was named after the case of Henry Wood Construction versus Malmaison Hotel, which is the most widely adopted and accepted in the industry. And what does this approach provide for? It provides that if one of the causes of delay in any given concurrency situation affords grounds for extension of time under the contract, the contractor should be given extension of time, notwithstanding his own default. I just remind you again, we said before when we started with foundation principles, contracts do not have to be fair, and this is one of those cases. The contract is entitled to extension of time for the period of delay caused by COVID-19 and the subsequent lockdown and the risk-adjusted levels that follows that. Scenario number 3. Contractor was in culpable delay when the lockdown commenced. In other words, he has already exceeded the due completion date by 26 March 2020 when the lockdown commenced. Culpable delay is when a contract is in delay, which is the responsibility of the contract. In other words, these delays were caused by the contractor and is not something that he could claim for. So if employer risk delay is incurred whilst the contract is in culpable delay and the contract is entitled to be granted an extension of time, what the effect of the employer risk delay on achieving completion by the due date. So there is still an entitlement to claim for extension of time, although the contractor is in delay and already exceeded the due completion date when the lockdown commenced. There are two methods that exist in determining extension of time due during culpable delay. The one is the gross method or the net method. I'm not going to go into the gross method, but what I can say to you, the net method is the correct method, which was supported in the Balfour Building versus Chestermount Properties case in 1993. And this was also supported in the Walter Lilly case. So the regional completion date is extended by the effect of the employer risk delay, and that's only the net effect of that. And in the Balfour Building case, the judge also clarified where the relevant event arose after the date of completion and the contractor was in culpable delay. The contractor would only become entitled to net extension of time corresponding to the specific number of days of delay occasioned by the excusable delay. Just to clarify this point, the contractor may have been, for example, when the lockdown commenced, he was already 2 weeks in delay, and then the lockdown was for 2 months. The contractor cannot claim 2 months plus the 2 weeks. He will only be entitled to claim for the lockdown period as it affected his time for completion. Scenario number 4, the contractor could recommence with the works on the 4th of May 2020, but his production is affected and disrupted by the COVID-19 occupational health and safety measures as gazetted on the 29th of April 2020. Delay, we're talking about disruption now. The productivity will actually cause delay in achieving completion of the works by the due completion date, disposed of by a cause and effect analysis of the reduction in productivity with completion. And this can only be realistically and practically. It is advised that the employer's agent and the contractor may have sit together and that the contractor will have to explain. In other words, the delay occurred after the completion date has already expired. Now, this question comes up quite often. The provisions of the contract remains applicable even once the due completion date has passed. Once the due completion date has passed, it doesn't mean the contractual obligations and revenues are not available anymore, they are still applicable because the contract is still alive even if the contractor has not achieved completion yet. Now the entitlement to time-related general items. Clause 512.3 of GCC 2015 deals with the relevant adjustment to general items in the event of an extension of time. What does it say? If an extension of time is granted, the contractor shall be paid such additional time-related general items, including for special non-working days if applicable, as are appropriate, and I'm putting that in bold, regarding any other compensation which may already have been granted in respect of the circumstances concerned. Now, clause 512.3 of GCC 2015 provides an automatic entitlement to the payment of time-related general items. So once the employer's agent grants an extension of time, then the payment of time-related general items is an automatic entitlement. Now, just to deal with the word as appropriate, clause 512.3, and if the word appropriate is not there for the purpose of discretion as to the appropriate amount payable, that is not what clause 512.3 actually provides for. The word appropriate has been provided to prevent double payment in the case where other concurrent extension of times may already have been granted. It may have been that there have been other delays and extension of times that must also be considered. That's why the word appropriate has been brought in, so that there's no double payment in terms of time-related general items. Now, GCC 2015 clause 11121 provides the following in terms of the definition of general items. General items means items stipulated in the pricing data relating to general obligations, site services, facilities, and or items that cover elements of the work, of the cost of the works which are not considered as proportional to the cost of the permanent works. In other words, general items is payable as a function of time and not as a function of production. The time-related general items are therefore not related to the cost of the permanent works certified in a given month. In other words, it's not a pro rata calculation to the cost of the works, it's a function of time. So the contractor is therefore entitled to the payment of time-related general items during the lockdown period, although no physical work was done. And it's quite important that in terms of general items and the definition thereof, it's not a claim that a contractor has to submit during the lockdown period. If the contract is still alive, the contractor is still busy carrying out the works and the due completion date has not arrived yet, then the general items during the lockdown period is still certifiable and payable to the contractor, although no permanent works was executed during the lockdown period. So that is dealt with extension of time. Let's look at the assessment of the contractor's proven additional cost claim. Scenario number one, the contractor is not commenced with the execution of the works when the lockdown commenced and only the contract commenced. In other words, the contract was signed. The commencement of works instruction has not been issued yet. Clause 832 of GCC 2015. If in carrying out the works, and we've underlined that any of the accepted risks causes the contractor to suffer delay to completion and or brings about proven additional costs, the contractor shall be entitled to make a claim in course of clause 10.1. So in this case, the contractor must still be awarded an extension of time, but if the contractor has not started with carrying out the work yet, he will not be entitled to the proven additional costs in terms of clause 8.3.2. In scenario number 2 to number 4, the contractor was busy carrying out the works whether on program or not when the lockdown period commenced. Clause 832 of GCC 2015. If in carrying out the works, and I'm not going to repeat this clause again, if the contractor has already been carrying out the works, then the contractor will be entitled to a proven additional cost claim. So let us look at the legal principles of proven additional cost. and this is a question that comes up quite a lot, especially due to the COVID-19 claims. Additional costs are incurred due to the following. It's loss of productivity, it's disturbance, it's hindrance or interruption to the contractor's normal working methods, resulting in lower efficiency, or in the case of COVID-19 and where there was a lockdown, no efficiency at all. And such a claim must be supported by evidence of facts, and yet again the burden of proof is on the claimant when it comes to a proven additional cost claim. Now the word proven implies that the contractor will have to prove the cost by providing records or evidence of the cost. Now cost is not defined in GCC 2015, there's no definition for that, but in terms of the management guide, it simply means the price paid for a thing. Now GCC 2015, there's no differentiation between cost with or without profit. In terms of the management guide, the proven cost will include the hard cost, the cost of the resources, and the soft cost, markup and profit. Now, proven additional costs during lockdown, the contractor will have to demonstrate that he had no option for mitigation, because mitigation is a principle in our law that if one suffers financial damages, he must also try and mitigate. The COVID-19 situation is unfortunately unique, as the whole of the industry came to a halt and the options of mitigation were almost non-existent in this case. So consideration will have to be given to the planned resources that were required by the approved program during the period of lockdown versus what the contract is claiming. And just on this point, to assess the proven additional cost during the lockdown period, for example, the assessment of the approved program and what was the contractor supposed to do during that period will have to be used as the basis to determine what resources would have been required during that period in terms of what the contract is claiming. So there's a comparison that can be made between that. Now, transparency is important, and it will be required by the contractor in terms of other monetary relief received in terms of UIF or TERS funding. And then transparency in terms of the contractor's tender makeup may be required, as well as rental agreement with construction equipment. And that's also an issue that comes up in the questions that we receive. If the contractor has rented the plant, is he supposed to pay for the rental company for the equipment? It all depends on the rental agreement that is between the contractor and the rental company. So that will also have to be interrogated. Now, in terms of proven additional costs during level 4 and level 3, so in this case, the contractor could now start working, but his production is impacted with. The most favored method of looking at on the assessment of that cost is the measured mile analysis. And that compares the actual cost with what the cost would have been were it not for the disruption. And that involves an evaluation of disruption carried on the basis of a comparison of productivity prior to the disruptive events taking place with the productivity during the period of disruption. So it will be based on the actual loss and expense incurred instead of references to tender allowances. And now the employer's agent will have to look at what did the contractor allow in his program in terms of productivity, because that will form an important basis of comparing what is allowed on the program versus what the contract is actually now achieving, if there's any impact on his productivity while working now after the lockdown period, and the impacts of health and safety due to COVID-19. And this measured mile analysis was the favorite method approved by the court in the matter of Whittle Builders versus Chester Lee Street District Council, and was also considered in John Doyle Construction versus Line Management case, and it is deemed as the acceptable method in assessing the proven additional cost due to lower productivity. And that, Chair and Stephen, that is our presentation. And I think it will be appropriate time then to deal with questions.
Right. Thank you, Theunis. I must say, the more I listen to what you've just presented, the more complicated I realize the whole situation is, and there's so many different scenarios and variations. Okay, so we received a few questions from the delegates who registered prior to the start of the webinar. So I'll start off with them, and then there's about 13 or so, about a dozen questions that have arrived from the delegates during the presentation. And if we don't make them through Refillware, will we actually be able to answer them and then distribute them along with the link to review the whole webinar presentation?
Yes, absolutely, Stephen.
Okay. So we'll look. Let's go through as many as we can, and then we will see how we do with it. Okay. So, here's the first one: is extension of time. Will it be with time-related costs, or can the employer deny the costs payable?
I think that question has been answered.
Yes.
If an extension of time is granted, the time-related cost that comes with the extension of time is an automatic entitlement, and the employer cannot deny the cost payable in terms of the contract provisions.
Okay. Then the next question was, may a contractor claim additional costs for instituting COVID-19 health and safety measure upgrades?
Yes, that is claimable because, as I said in the previous slides, that the accepted risk is a claimable event, and the accepted risk in this case has arisen due to COVID-19. And accepted risk are covering employer risk events and dealing with unforeseen costs. And obviously, these costs would have not been foreseeable when the contractor submitted his tender in advance of the lockdown and when COVID-19 came to South Africa. So yes, it will be a claimable cost.
Okay. Right. The next one was, in view of lockdown regulations, do all construction contracts get an automatic extension of time?
There's no such thing as an automatic extension of time, and I touched on that as well, is that the duty to claim for extension of time is on the contractor, and the employer and the employer's agent does not have to give a contractor extension of time just because the lockdown happened. The contractor must invoke the provisions of the contract, and if he didn't do so, he's not going to be entitled to an extension of time.
Okay, thank you. Right, the next one was, how much discretion does the dispute adjudication board have to assist the parties to negotiate a settlement?
The challenge with this question is that a dispute adjudication board is not there to negotiate claims with the parties. A dispute adjudication board is there to hear both parties' case and to make a decision. So if a party wants to go into negotiation or settlement of claims, they will have to consider the amicable settlement route and go for that process in terms of the GCC 2015 provisions instead of going to a dispute adjudication board.
All right. This next one I know you did touch on because I recall it, is what is the fair reimbursement for the labour content of a contract for COVID-19 lockdown period, considering the UIF and the temporary employee-employer relief scheme recovery?
This is quite an important question because this is where transparency and records will become relevant. So in consideration of claims for labour, the contractor will have to prove by records what did they actually pay for his labour during the lockdown period. There may have been short time that has been applicable in the case, and proving that by pay slips, and if there was any UIF or TERS recovery, then the contractor will have to deduct that because he cannot be paid or receive double payment for that. So that will have to be given to the credit of the employer.
Okay. Right, the next question was, the contractor's completion date was before lockdown and he wasn't complete. So the contract was in penalties. He has now obviously incurred costs over the lockdown in terms of the salaries, plant, etc., and has submitted an intention to claim according to clause 832 of GCC 2015. How would this be handled in this circumstances?
Now, if the completion date was before the lockdown period commenced, the contract is still alive, the contractual remedies are still appropriate, and the contractor can still claim an extension of time. But the extension of time for the lockdown period will only be for that period and not, it will be according to the net method as I explained in the presentation. So the contractor can still claim an extension of time for the lockdown period.
Okay, all right. If the works had been damaged during the lockdown because the contractor could not constantly protect the works when required, why is the client liable to pay for the remediation of the damaged works?
That's also quite an important question because whether the works were suspended by the employer or whether the contractor had to shut down the site and claim an extension of time due to an accepted risk, the contractor remained responsible for the site and any risk of damage to the site due to stormwater damage or whatever it would be. So that would be a contractor's risk for that period of the lockdown, and the client would not be liable to pay for that. And that is why it was important that contractors, when the lockdown commenced, that the sites were made safe and everything would have been done to make the site protected against damage of the works.
Theunis, would that include damage by vandalism during lockdown? I mean, you know, in a situation where they couldn't offer protection, but, you know, the lockdown through the situation, you know, there were vandals on site and the works were damaged at that point. Who's then liable? Still the contractor.
The contractor would have had to put security measures in place because the contract provisions is clear that the contractor remains responsible for the protection of the works if the contract is still alive.
Okay. And then how do you deal with proven costs regarding the recovery of cost of head office overheads?
Now, head office overheads is not a proven cost item. Head office overheads is part of your time-related general items. And what is important in terms of this question is that any item that is part of a time-related general item does not have to be proven by the contractor. The only thing that the contractor has to prove when it comes to a time-related general item is what was the rate tendered in the BOQ. And those rates, whether it was too high or too low, those rates will be applicable in determining the time-related general items. And in this case, head office overhead is part of the time-related general items, and it doesn't have to be proven by a contractor.
Okay. I'm going to skip question 10 if you don't mind. It's a very long question. So I'll go to 11. Is what proven costs, in addition to the time-related P's and G's, will be payable to contractors for the COVID-19 lockdown?
As we said, except for time-related general items, proven costs that will be payable maybe for labor that the contractor had to pay during the lockdown period, especially labor that couldn't be put on short time. It could have been for construction equipment that could have been put off hire and rental agreements had to be honored on the contractor's own equipment. It can even include subcontractors' claims. Once again, transparency is important. The contractor will have to prove that he received the subcontractor claim and that claim will also have to be interrogated.
Okay. All right. Okay. Are claims for standing time valid when the contractor would not possibly be able to employ their plant and labor elsewhere during the lockdown period?
This is a question that comes up quite regularly. Yes, a contractor must try and mitigate his claim. In normal circumstances, what would have happened with individual events is that if a contractor suffers delay on one site and there's an opportunity to mitigate by taking the construction equipment to another site. That is what would usually happen. But the situation with COVID-19 during lockdown period was quite unique that the whole of the industry came to an halt. So the contractor's options for mitigation was, as I said in the slides, was almost null. So the contractor would be entitled to claim for standing time for construction equipment in this case.
Okay, there's a question here on GCC 2010. I don't know if you want to deal with that. Contract using GCC 2010, clause 8.3, accepted risks, pandemic is not listed.
That is absolutely correct. Epidemics and pandemics are not listed in GCC 2010 as an accepted risk, and I can only say it's going to become quite interesting how claims under GCC 2010 will be dealt with when it comes to the proven cost item. Under GCC 2010, the time-related extension of time and time-related claims will be quite straightforward. But I believe under GCC 2010, it may become challenging for contractors to pursue that.
We did release a notice, am I right, Theunis, on the impact of COVID on GCC 2010. I'm not sure if there was an attempt to try and help contractors address the claims in GCC 2010.
Yes, there is a possibility, and it's all going to depend on contractual and legal interpretation in the future that changes in legislation may be an applicable clause for contractors, but I think that still needs to be tested in the future.
Okay, nearly at the end of this first list, the project was in process of snagging and practical completion was achieved before the lockdown commenced. Is an extension of time claim still applicable due to the COVID-19 pandemic?
Now, in terms of GCC 2015, an extension of time is an extension of time for practical completion. So if a contractor achieved practical completion before lockdown commenced, obviously, you cannot claim for extension of time anymore because you already achieved practical completion before lockdown. The only remedy that will be available to a contractor is to claim for additional cost due to the lockdown period and not for extension of time.
Okay, and then the last question here is, what if the contractor claims P's and G's during COVID-19 while he claimed de-establishment? The contractor, the fact that the contractor may have de-established from site did not mean that he surrendered the site and the site reverted back to the employer and that the contract is not alive anymore. The purpose of the establishment may have been that the contractor rather take the construction equipment to his local yard. It would be easier to secure it and look after that there. So the de-establishment of construction equipment does not take the entitlement away to still claim time-related general items for the lockdown period or for the delay caused by the lockdown period. Thanks, Theunis. Okay, Rafiel, we've got now 40 questions. How much time have we got? Because it's going to take a while to try and work through some of these questions.
We have about 20 to 25 minutes.
Okay, all right, let me get going. There's a question here from Neo. If the contractor is behind progress before lockdown, the contractor was not performing any activity, is he still entitled?
Yes, he's still entitled to claim an extension of time.
Even though he wasn't actually performing and behind progress before lockdown?
Yes, I've dealt with that under culpable delay. The contractor may have been slow in performance or may have been delayed. The extension of time due to the lockdown period is still a claimable event because the contract is still alive. The appropriate remedies in the contract is still available.
All right, I've gotten a question here from Osvaldo. If there is an agreement between the contractor and the client to remove the equipment from site before lockdown came into effect, can the contractor still claim for this equipment?
He can still claim for the equipment provided he didn't use the equipment somewhere else and had an opportunity to mitigate.
Okay, Fahim, how does the contractor prove standing time claimed if asked by the EA? EA meaning?
Employer's agent.
Oh, the employer's agent. Shall day rates be appropriate to use it as the BFQ rates?
The straightforward answer in proving rates may come down at the end of the day to the tender makeup. And it's all about intent. The best way to prove intent at the end of the day is to say, listen, let's look at the tender makeup for the specific project, and that's why there's a tender build-up that's done by contractor, whether they use Candy software or they use Excel or whichever way they did it. The best way for a contractor to prove those rates is how was the tender made up before anybody knew about COVID-19 or the effects thereof, instead of looking at plant hire rates or industry rates. So in that would be the best case scenario to agree on what is the rates applicable to the specific project or equipment.
I've got a question here from Hardy. If the float belongs to the project due to the fact that the float was not expressly dealt with, will the float be used up in the evaluation for extension of time?
Yes, and that's a good question, because sometimes there is float available in the program. So I would like to answer that and also make the statement that a delay of 1 day is not necessarily a delay of 1 day to the due completion date. So the best way to assess the impact of COVID-19 is to plug that into the electronic program so that the float that is available in the program can be absorbed before the due completion date is impacted.
Okay. Question from Neo. I'm not sure if it's a question or an observation. There's an observation. There's a huge variation in costs being submitted by contractors for similar activities, e.g. procurement of PPE, transport costs, accommodation, etc., some of which look unreasonable. The challenge is for the employer's representative to be fair to both the employer and the contractors in adjudicating these claims. So I don't know if you want to comment on that. It's more of an observation.
I would like to make the following comment. The employer's agent only has 28 calendar days to assess these claims, and I think it's in the interest of both parties to interrogate the impact of all of these claims. And it's not one claim at a time now. It's in every part of the construction industry on all sides there are claims. And interrogate these cost failures, I think the parties must give each other sufficient time and rather agree on an extension of the 28 calendar days to rule by another 14 days or whatever is needed, so that the employer's agents can do a proper assessment before the matter becomes a dispute.
Okay, here's an interesting question with a quick answer, I think, from Peter. The contractor left the site before lockdown. So around February, March, he was not on site due to his own cash flow problems, and he then still claim an extension of time with cost.
The observation would have been did the contractor abandon the works, and that should be taken into account into, and was the contractual remedies followed if the contractor abandoned the works, because a contractor cannot suspend on his own account. GCC 2015 is quite limited on why a contractor can actually suspend, and that would be non-payment or only part payment on a payment certificate, or when an interim payment certificate is not issued. There's no other reason why a contractor can suspend. So that suspension of the contract, if you can call it like that, is actually not contractually sound.
Okay. Question from Carl. Some contractors have not yet received their TERS UIF payments and are asking the employers to pay the full amount of labour cost, stating that they will provide a credit back to the client once the TERS payment is received. Would something like this be acceptable, especially as we are unsure of the period required to obtain the TERS payment? I'm not sure if you're able to answer a question like that.
The reasonable thing to do in the circumstances is that the employer's agent then issue an interim ruling because the final cost cannot be determined, and once an interim ruling is issued, that ruling becomes payable to the contractor, and once the credit comes through, then the employer's agent can issue his final ruling, taking the credit into account.
Okay. All right, I've got a question here from Rafhiwa. What happens if you receive no notices from the contractor? And what happens if the contractor delays the recommencement by overcharging huge prices, the mitigation plan for COVID, and the submission was overruled and still delays? I'm not sure if that makes sense.
Well, if the contractor did not submit any notice, then obviously there's not going to be an extension of time or proven cost claim that's going to be awarded.
All right, I see Hardy asked a question on ownership of the float, but I think you did cover that. Uma asked a quick question here. The additional costs for daily screening and additional transport to deal with, sort of mitigating the risks and putting in place the measures, do they form part of additional costs?
Yes, they would form part of additional costs because all of it flows from the accepted risk, and the accepted risk is COVID-19. So it will all be covered under the accepted risk clause, under clause 8.3.2.
Okay. All right, a question from Charles. If the contract contains standing time rates and the contractor has claimed these as additional proven costs, can the employer agent ask for a breakdown of these standing rates to strip out the elements such as fuel and maintenance?
I would absolutely agree with that because the standing time rates may have elements that are already covered in other items. So it would be only reasonable from the employer's agent to ask for a breakdown. And usually they are referred to as day work rates as well in the bills of quantities.
Right, question from Errol. What if there is no approved program due to the contractor not making requested amendments to a submitted program which was not approved by the employer's agent?
In the absence of an approved program, the employer's agent is fully entitled to make his own assessment of what the program would have been for that period, and then make his assessment on the additional costs that would have been coupled to that program for that period of time.
Okay, here's a question that looks at it from the consultant's point of view now. This presentation mainly dealt with contractors' claims. What about the engineer's claims due to the extension of construction? Can the engineer claim from the employer to extend his construction monitoring contract?
The consultants will have to do that because the professional agreements also has a time for performance in it, and especially if you look at the standard professional agreements, once a project is delayed, then the consultant will also have to invoke the extension of time clause that goes with that, and obviously the financial remedies that comes with that.
All right, here's a many from Carl again. Many contractors are claiming, I think that's day rates, is it? Not dry. Claiming day rates for plant, and some employers are not in agreement with paying such rates. How would the employer's agent then go about trying to give effect to clause 3.5 in getting the parties to agree?
As I said before, if everything else fails, the best way is to go and look at the tender makeup for that specific project, because if you want to prove any intent, the makeup of that tender should have a makeup of what did the contractor allow for an excavator and grader, what was the rates, because that will be the contractual or the makeup of the contractual rates at the end of the day. And that obviously will require transparency from the contractor to put that on the table.
Okay, some of these questions are repeating themselves a bit. Rathiwa, if the contractor is already behind prior to COVID-19, can an agent approve an extension of time without cost to the employer on delays prior to the COVID-19 and grant cost on the COVID delays? Have we...
Yeah, I think we've covered that, but
covered that
I'll just repeat that. Whilst the contract is still alive, the remedies are still available. And if the contractor is entitled to an extension of time, he is also automatically entitled to time-related general items with the extension of time granted.
Okay, there's another question on 2010 with the fact that the term pandemic doesn't appear there. How do we deal with inflation after lockdown in ongoing construction?
It depends on the contract price adjustment clause. If there's no contract price adjustment, then the rates and prices is fixed in the tender.
Right. I'm just looking through the balance of these questions, Rafael, where I think a lot of them are repeating and a lot of them are actually, one of them here is asking for a bit of an explanation of the act of prevention. What does it mean?
Acts of prevention. Now, in this case, COVID-19 was preventing the contractor from working during the lockdown period, for example. In terms of the accepted risk, that act of prevention, although the employer did not cause the prevention, it is an employer's risk.
Okay. Question from Ruan, but I think you again probably dealt with this. What if the contractor submits his claim before the end of the circumstance giving rise to the claim? I think you spoke about that, especially with the extension announced for the lockdown.
Then the contractor has basically bolted the horse and he's got to live with the claim that he submitted, unless he's going to get some grace from the employer's agent to submit a further claim.
Okay. I think, Rafael, we're pretty much covered it, but I think if you want to pass these questions on to Theunis to maybe elaborate on the ones that maybe weren't a duplicate as I thought, then you can do that. But I think we've been through all the questions more or less. Thank you.
Thank you so much, Stephen, and thank you for moderating the session so efficiently, and to Theunis for the thought that you put behind putting your presentation together. You painted many scenarios, which I'm hoping that spoke to quite a lot of the participants who joined us today, and that they found a lot of value in what you said. I really hope that the participants also found value in and also learned something from the other participants' questions, because some of them were quite important questions that Theunis had to address. And we would really like to thank you so much, Theunis, as I've already mentioned, for the effort that you put in towards taking your time. As mentioned earlier, in order for us to continue serving you guys, which is our participants and our members, please participate in our survey in order for us to be able to come up with topics that can actually bring value to your careers and to your businesses. Now, moving on to what our next topic is going to be. June is Youth Month. And in commemoration, we are going to make sure that our next webinar focuses specifically on our youth. That being our young engineers, technologists, and our technicians who might be preparing or thinking of preparing for their registration as professionals with EXA. We are going to put together a panel which has presenters that will patiently take us through the registration requirements and the process. And it is our aim to be able to help our members through that daunting task of preparing these reports, and also to help you build your confidence by providing you with the tools so that you can cruise through that nerve-wracking interview. Now, putting together these events is a demanding process, which requires a lot of coordination, time, and effort. I'd like to convey my sincere gratitude to the SAICE branch team for their professional work and these wonderful webinars that are always such a success. I checked the numbers earlier, I see that we had 198 people who joined and actually stayed on throughout the whole webinar, which shows that the content of the webinar is what people want to see. And I would really like to thank Refule Lidiga, Karabo Muhlame, and Priska Mhlongo. You guys are just absolutely amazing. You work tirelessly behind the scenes to make sure that every event that we host is a success. Would also like to thank SAICE National Office for their support throughout all our endeavors to put out our webinars. They are always very supportive. We also like to thank SAICE UCT. They actually started distributing the advertisement for the webinar. So you guys made this webinar possible as well. And also to everyone who took upon themselves to pass on the invitation, would like to acknowledge the contribution that you've made. Our greatest gratitude, though, goes to you guys, the participants. Thank you so much for taking your time to register and to actually join the sessions. It's your participation and the questions that you ask that make these sessions a success. In conclusion, I'd like to say that the COVID-19 pandemic has and continues to have a devastating impact on the health, the country's economy, and our people's livelihood. I would like to acknowledge the momentous task that is facing our leaders and decision makers who have to make knife-edge decisions on a daily basis in an attempt to keep a balance between the health of our people and the risk of non-recovery of our economy. And from SAICE Johannesburg, we would like to encourage everyone to continue doing our part. Let's help flatten the curve and make sure that we do not overwhelm our health system. So we all have to do our part, guys. Thank you to all of you participants, and thanks to everyone. I would like to wish you safety and health up until we see each other again. Thank you. Bye.